to represent the estate, which gets paid by the estate. And that's money that's to be given to the beneficiaries. So it's never in the best interest of everybody to do that. Now, obviously, there's extreme scenarios and things happen and people have points that they truly believe that they're not being treated fairly and whatnot. And I'm speaking frank, and even for us, right, when we're talking about from the Islamic perspective, the Sharia perspective, we know the distributions and how that happens. Unfortunately, people have issues with that and contest that, right? So those things can and do happen. And that's where it gets to being easily contested, right? Anybody can just step up and make a claim. So this is how the will operates. And I'm not, again, it may sound like, and everyone's probably thinking, well, why would anyone ever do a will, right? And I'm not making it sound negative, I'm giving the facts of what it is. So that's how it actually works. So how do you contrast? So what's the other alternative, right? So now, let me, actually, before I even get to that, so there's three ways. So the question isn't, okay, I want to, not do a will. The question usually becomes, how do I avoid probate, right? The will itself is not the document that people want to avoid. It's trying to avoid probate itself. And you can have a will, which I said goes through probate, and also possibly avoid probate, right? Because there's three ways to avoid probate. You have joint accounts, right? We mentioned that earlier. You have beneficiaries. Okay, so if you've got, your investments, you've got your IRAs, even bank accounts, you can add a beneficiary to your bank account. And then the third way is the trust, is which we'll talk about. So, just on the other two, joint accounts and beneficiaries, right? So I mentioned earlier that you don't want to put your kids joint, which I still stand by. You don't put your kids joint on the account for the simple reason of avoiding probate for the various reasons that there are. You obviously, with your spouse, you have things joint, right? And many people do. So yes, you pass away, automatically, everything would, in that sense, from under state laws I'm talking right now, goes to the spouse. And then from the Sharia aspect, that's, a conversation that it all works in that way too, but we can hold off on that conversation right now. Beneficiaries, same thing. You pass away, you've got your spouse as a primary maybe, you've got your kids contingent. So it automatically avoids probate and it goes to them, okay? But when we talk about, or at least when I specifically talk about estate planning, it's not necessarily the planning after the death of the first spouse, it's the planning after the death of the second spouse, right? Because after the death of the first spouse, yes, there are ways to avoid probate without having to go through the trust option, right? You've got those two ways. But what if when the second spouse passes away, right? And we're still on the whole, I'm not going to put it's not advised to put your children on your bank accounts and whatnot. In that scenario, how would that work? What if husband and wife are traveling and they both pass away together, right? What about in that scenario, right? So it's scenarios that could seem unlikely but possible, right? And unfortunately, we've been hearing these unfortunate situations happening. So in that, it becomes where yes, you can avoid probate by doing one or the other, but is there a way to do it where you don't have to worry about that, where if something happens to both of us at the same time, or in the extreme unfortunate situation, if something happens to the family at the same time and whatnot, how do we make sure everything goes the way we want it to, according to your wishes and according to the Sharia as well? That's where the trust comes in, okay? So, what does a trust do? First off, you see, right, it avoids probate. And I'm going to talk about why. How does a trust avoid probate? And the example or the analogy I always give is so we mentioned earlier, right, that anything that's titled in your name is what goes through probate. So what a trust does is that it takes it from your name and it puts it into a trust. Okay? So you transfer it into the trust. Now, the best way I can explain how the trust works and to visualize it is think of a bucket. You have a bucket, and right now the bucket is empty. Okay? There's nothing inside your bucket. You put instructions inside the bucket, you write a piece of paper, and you say to your trustee, the trustee is the person who represents your trust after you've passed away, who now reads, you passed away. This trustee goes to your bucket, looks inside, and it says, anything that I have inside this bucket goes to my children. And I'm just giving you the example, the simple beneficiary example. Anything that's inside this bucket goes to my children. Right? Now, one of two things can happen. There could be nothing inside the bucket, which means nothing in the bucket will go to the kids. Or you can have everything inside the bucket. If you have everything inside that bucket avoids probate. If you have 50% of your assets inside the bucket and the other 50% outside of the bucket, then whatever is inside avoids probate, whatever is outside will go through probate, because what's outside, it's still in your name. And we mentioned that if it's in your name, it goes through probate. So that's how the best way I think that I can explain on how a trust functions. So the objective becomes that you use this trust to funnel all of your assets into the bucket while you're alive or after you pass. Meaning, you either, let's say you open up a new bank account and you have a trust, you open it in the name of the trust. Or you add the trust as a beneficiary to all of your assets. So the objective again is that when we pass, everything we have is going to go inside here. And then once it's inside, I've got instructions listed that says what is supposed to be done. When you do that, you avoid probate. It keeps it all private. Nobody knows what's in, who's getting what. You don't get courts involved. You don't get attorneys involved. You can have provisions that if somebody's going to contest my trust and they get nothing, I mean, you can control however you want in what you do. From a cost aspect, you can pass away with $500,000, you can pass away with $1 million or $5 million. There's no extra cost, there's no inventory fee that you're paying to anybody. You're just paying whatever the cost may be to set it up, and that's it. There's not an annual maintenance fee or any of that. So you get more flexibility with that. And especially when you have minor children, and we'll discuss a little bit on that in a few minutes. It's a much smoother process. The transfer of assets can happen almost immediately, right? We talked about probate where it can take 4 to 6 months because that's going through court. The court has to finalize, and you got to close and disperse the assets and then close the estate. With a trust, it literally can be that you pass away, the next day your heirs and your beneficiaries can receive everything that's inside the trust. Your bank account's got X amount in there, next day it can start being used for the funeral expenses, for the kids, or whatever it might be. You can start using the funds right then. So it's a simpler process for the most part when it's done right. So I always mention this, the part where I stated where you want to put everything in the bucket, that transfer of assets from you to your trust is what we call funding, right? You want to fund your trust. If you don't fund your trust, then your trust is just as good as a will. Okay, so there's 2 steps to the trust process. It's establishing it, creating it, getting it signed and executed, and then making sure you're transferring the assets inside. Okay, if you don't take that second step, then you paid money for something that would be costing you even more now because you paid money for a trust and you're still going to go through probate, right? So keep just to be mindful of that. I also mentioned just on an estate planning as a whole. Your estate plan, I always say, is never complete until you die. It's always changing, always evolving. There's always things happening. Just earlier, today, I had a meeting with somebody and did hers 7 years ago. Did a will. I'm sure she's an ophthalmologist. She's got married. She has 2 kids now. She's got a practice and she's got real estate. So it's constantly evolving. If your kids are minors today, a few years later, they get older. Things can change. Get married and whatnot. So there's always changes to it. I take what I say the morbid mentality when you do your estate plan is when you're getting ready to draft and say, all right, let's take this step, plan it for 1 to 3 years. That if something happens to me or us in the next 1 to 3 years, what do we want done? How do we want things to happen? Right? Because beyond that, like, for example, if you're planning today, you have a kid that's 15 or 16, after 3 years, they'll now be adults, right? And when they're 16, you might be planning for one way, and let's say you've got 1 or 2 others that are minors, but when they're 19 and 20, you might now say, okay, well, now I want that child to be the guardian of my minors now, right? Because they can't be guardians when they're minors, but now that they're older, now that changes, right? So you want to do that. As they get older and more hopefully mature and wiser and more financially responsible and whatnot, you get more comfortable in how your distributions to your children might take place and so on. So a lot of it is always evolving. Okay, so very simple on this, and it's I'm not tech savvy and PowerPoint good at all, but this is essentially just what we talked about. When you talk about estate planning, you talk about will and a trust, right? The life after death planning. Your end result will always be the same. At the end of the day, whether you do a trust or you do a will, it's always going to go to your beneficiaries. The question becomes, how does it get there? Right? A will is going to take a little bit of a curve. The trust is going to be more direct. The result will be the same, but it just takes a little longer with the will than it would with the trust. Okay, 2 slides left and I'm done, I promise. What else to consider? Part of the planning is, when we talk about distributions to your beneficiaries, I'm not talking about who gets what, but part of the process could be, how do they get it, when do they get it, and in what phases you may want it to be given. It's theirs, the money is theirs, but you may not want that your 18 or 19-year-old son possibly to receive an inheritance of X amount, right? It's their money. You're not saying I'm holding it back from you, but it's just a matter of, let's make sure that it's given in a financially responsible way, possibly. So that process is part of the planning as well. It's how do we want it to get to the kids, in what stages of their lives would we want? We want to make sure their university and schools are paid, and then it gets to maybe percentages every year or whatever it might be, right? So you have some control over that as you do your plan. Business assets and real estate investments, right? Just we touched briefly on that, right? That's also things to consider. Now, business assets is also a similar conversation but different. That's succession planning, right? So if you own a business, similar to the question that gets asked, and I respond with the question with kids, right? If something happens to you, what happens to your kids? Same thing with the business. If you own a business and you've got partners in your business, okay, and it doesn't just have to be in a business that is fully operating like a restaurant or a store or anything like that. It could be an investment, right? A real estate investment, whatever it might be. The question that gets asked is, if you pass away, whatever equity that you have, who gets it? Does it go to your partners or does it go to your family? Right? And similarly for your partners, if they pass away, what happens to their equity? Does it go to you or does it go to their family? Oftentimes, if you're in a partnership with somebody and they pass away, you may not want their kids or their spouse to now become owners of the business, where now you never worked with them, you don't know who they are, you don't know what they do, they have no experience in the area, the industry, but now they have equal say as you and equal partnership rights. So that's succession planning with the business aspect of things, right? So that's another conversation that gets had when you have a business, and just things to be thinking about on how that would transition. That also gets part of the estate plan, right? When it comes to succession planning, it can never happen without a conversation of an estate plan, right? So the same thing with that is, you've got assets, how does it go to your beneficiaries? And what mechanism will that take? Is it going to go through court, probate, or can it be a little simpler? Okay, Last one is essentially just kind of concluding here. So, when should I plan? And I kind of talked about this earlier, right? So there's two different parts to that. It's when should you, and unfortunately, when do people actually plan? The should, if you, kind of got through this, has been really as soon as you can, right? It's immediate, right? We don't know when our time is. So Dan, it's always how soon can somebody do it? Reality hits, when do people actually plan? Unfortunately, it's when something tragic happens personally to them, or to somebody they know, or something in the community. That's usually what triggers people to say, you know what, that just happened, we're going through this now, what do we have now? And that's usually when people start to plan. So the idea, and hopefully inshallah, is that it should be, on the should side, should be more on the immediate side, as opposed to when do people actually do it. So what do you do next? Like I said, overall, if there's one thing I'm hoping people got out of today, it's a good, clear understanding of a will and a trust, right? There's the misconception of a trust. It's, too costly and you gotta be super wealthy and whatnot. There's pros, I'm not gonna say cons, there's pros for both, right? A will can be a functioning document for somebody, depending on their circumstances. A trust can be a functioning document for somebody, depending on their circumstances, right? What's best for you, but what you can at least get from today is a good understanding of, I know my assets, I know what they're worth, I know what probate could potentially cost me. Is there a better option, right? Now I'm sure everyone's thinking, okay, well, what do the trust cost me then? So a trust can range anywhere from about $1,500 to maybe $1,800, $1,900. Obviously, if somebody's got multiple businesses and all that, it can fluctuate. But usually, that would be the range that I would say you would fall into for the average person. So now, with that framework in mind, with that thought, you can calculate yourself in what could probate possibly cost. And and the question becomes paying something today versus paying something later. So again, there's pros for both. It's what's best for you. So you want to list your assets, understand your plan, understand what an estate plan is, post-death, pre-death planning, and talk to an attorney, inshallah. But Jazakallah khair. That's the end of my presentation. I know we're going to do Q&A, so inshallah, if anybody has questions, I'm happy to answer. Sorry, yeah, you had.
We have some.
Yeah. Sorry, go ahead.
Suppose we have some asset overseas, we inherited from our family, how it can be handled in this?
So the question is that if you have assets overseas, let me just step over here. They have assets overseas. How do you handle that here? So that usually would be governed by the laws of the country that you're in, right? So for example, if it's in let's just say Pakistan, then they have their own laws and how that gets handled. That would govern there. The U.S. documents won't typically be enforceable in another country. Now, what we do though is what I advise is mention that in the trust here, right? So the idea is that or your estate plan overall, the idea is that you want to make your representative, whether it's a personal representative or your trustee, you want to make their job easier. The way to make it easier is by listing out all your assets, right? So if they don't know you have property, let's just say overseas, then they won't know that there's something to even do over there, right? And just even more, if you bring it home more, it's if they don't know you have an account at Chase and you might have an account in, am I?
Yeah, okay.
Okay. So if they don't know you have an account at Chase Bank or you have an account at Huntington or Fifth Third, then there could be money sitting in an account that you have no idea. So it's always good, and whenever you do an estate plan, to list out all your assets. List out the bank that's at, the bank account, if you've got investments, a financial advisor, it's all to make their job easier because they don't have to be guessing and thinking, a lot of time it might be your kids that are doing it, so like, where did mom and dad have this, or what else do they have? So that would be what we always mention is reference it here, so they have an idea of that they have to do something there. Sorry, I know you had a
How does the pour over wills work?
good question. So you must have researched it before. So the question was, how does a pour over will work? So a pour over will is a backup document. So when you do a trust, along with the trust, you do what's called a pour over will. So it operates as a will, okay, but it is only used in two circumstances. One, if you've got minor children, that's where you nominate your guardian. So that will gets admitted to court to appoint the guardian. And two, if you go back to the bucket analogy, anything that you have in the bucket avoids probate. But if you have assets outside of the bucket, that goes through probate, right? This will, the pour of a will, lets the court know that for whatever reason this asset was not in the trust, we need to pour it in. The beneficiary of that will is the trust. So that's how the pour of a will functions. So I just want to make sure I don't know if there's any sisters that have questions. Yeah.
Why would someone avoid putting everything in the bucket if they've already created a trust?
The trust is your bucket.
Yeah, why would you avoid putting any of your assets in there? Why would you leave something out?
People forget. So you create a trust today, for example, 5 years from now, and this happens, 10 years from now, you open up a bank account and you forget to put the trust as the beneficiary, or you forget to put it in the name of the trust, and then you pass away, and then it's not there. People, and that's why it's always important that anytime you do any estate plan, every few years you should just be revisiting it. Because a lot of times what people do is they think they have it and then they just forget, and 20 years goes by and your power of attorney is different, your trustee is no longer around, your kids are much older, so it's always important to do that. So, but that would be one of the reasons people just forget. There wouldn't be any other reason for it. Yeah.
Do you need one trust per person, or how does that work?
So the question is, do you need one trust per person? Generally, no. With husband and wife, you can do a joint trust. Now, what scenarios can happen and does happen is an example of, and I just had this yesterday, where husband, wife, it was the husband's second marriage and had kids from a previous marriage, right? So in that scenario, the wife wanted to make sure, and I'm giving real life examples here, right? So I just want to I'm being open on this conversation about this. Wife wanted to make sure they had 3 kids, 2 of them were from his previous and 1 was theirs. She wanted to make sure that her son, and she goes that I love both my kids and raised them since they were, a young age, but her son, she wanted to make sure was protected. So in that scenario, she wanted to create a separate trust where her money would get to her, because if you have a joint trust, everything, and I'm taking the Sharia aspect away, right? Because at the end of the day, the intention obviously inshallah is always there, but if it's not executed by the other person, then that's on them, obviously, them and Allah. But in that scenario, she wanted to make sure that it was protected, where if I die, then this trust he cannot control. If he gets remarried, for example, he can't take that money and now start using it for his other family and whatnot. So that was one of her preferences. So in that situation, it would be created as you have your own, and then it could be a joint trust as well. So, sorry, you want a follow-up?
So when you go to your office, who all needs to come there to set up the trust for husband and wife? Both people need to be there.
So, good question. That example I just gave you, she didn't want her husband to know that she's creating a separate trust. So in that example, it was just be her. So the question was, who needs to come to set up, do your estate plan? But if you're doing a joint trust, husband-wife, then yeah, then both of you, for the initial consult, you'll have to be there. You don't have to be there for the consult, but when you're signing, you obviously have to be there. So just making sure the spouses are on the same page with what's happening. Yeah.
You talked about establishing a trust and transferring your assets. Can you talk a little bit about transferring assets while you're alive and after death with a couple of examples?
Sure. So the question was talking about transferring assets giving an example of transferring assets while you're alive versus after death, right? So let me just also, I just want to mention one thing. This trust that we're talking about, and this is obviously, it was the basics of estate planning. It's what we call a revocable living trust, okay? A revocable living trust is a trust that you can revoke. You have control over it, you can change it, you can alter it, you can do whatever you want with it while you're alive, okay? Also to know, a revocable living trust does not give you any asset protection. I get this question a lot, where it's in my trust now, and now I can get sued and they can't come after anything. No, a revocable living trust does not give you any asset protection. Why? Because you have control over the asset. Right? If you have control and access to it, you have no protection that it's giving you. Right? That gets into what we call an irrevocable trust, and for purpose of today, I won't necessarily get into that, but there are specific reasons that could be a beneficial. Now, maybe I'll get into a little bit, because it could be something for people to know. An irrevocable trust, what it does is, if you transfer something to and I'll get to your question, brother. If you transfer something to an irrevocable trust, you no longer own that asset. Okay? You no longer have control over that asset. That's why you have it protected. That's why it's out of your estate. So for any reason that you might have, that you get sued or whatever it might be, a creditor cannot come after that asset now. Now, what are some other reasons? If you have a child that's special needs, okay, and they're receiving governmental benefits, right? There's an asset threshold that they're allowed to have in their name. So if they receive an inheritance, they will lose that governmental benefit. So there's a trust that's called a special needs trust, where the trust, as an irrevocable trust, is the beneficiary for that child. But the purpose of that trust is for that child. Okay? Now, they don't have control or access to it. But the trustee is able to use the money that is in that trust for their benefit, with the exception of food, clothing, and shelter, because that's usually what the benefits are meant to be used for. Okay? So that's another example of an irrevocable trust. And the third example, again, just being open in this conversation, is you have a son or a daughter, they're married, and you are worried that it may not go well, and you don't want them to receive any of the inheritance, right? There's a worry or concern about that, and there's useful ways to use an irrevocable trust to protect from a son-in-law or a daughter-in-law or whatnot to have any access over your funds that will be inherited by your child, right? Because once it goes to them, inheritances are usually kept separate as not a marital asset, but once it gets mixed in and used for marital purposes, then it is a marital asset. And then if a divorce happens, then they have full right to say that they're entitled to half of that money. Okay, so that's just another thought that could, a reason that an irrevocable trust. Now, sorry brother, I haven't answered this question, I'm sorry. My wife says all the time, I always digress and I talk about other things. But the question was examples of transferring during life and transferring after life, right? Transferring during life would be, the simplest would be your house, right? You've got the house that's in your name, that's deeded in your name, you deed that, you take the deed, we draft a new one, and it transfers it into the trust, okay? As a simplest example. Bank accounts could be for new accounts that you open, right? You can put it in the name of the trust. Your existing accounts, you can, but usually what the bank would say is, you're gonna have to close this account and open up a new one because we can't change the name. Well, if you've got direct deposits and all that, it just becomes a nuisance. So then what you do is instead of doing that process, you add a beneficiary to the account. When you add your trust as a beneficiary, that's transferring it after your death. So right now it's still in your name, your personal name, but when you die, then a new account in the trust name gets opened, and it then goes to them. So there was a question here first, sir. Yeah.
So let's say, for example, you don't do no will or no trust.
What
And
happens?
bank account, cars, house. What happens versus the kids?
Okay. So the question is, if you don't do anything, right? Pretty much, you don't do any plan at all. So when you don't do any plan, you're termed as you've passed away intestate. That's the legal term that gets used. You passed away intestate. What happens then is your assets would still get distributed, but per state laws. So every state has its own formula. Michigan has its own. I remember back 14 years ago in law school, I remember, but it was like the first 150,000 goes to the wife, and then depending who else you're between the wife and the kids, or husband, kids, whomever, then there's some split between them. So that's how your assets would get distributed if you pass away with no plan at all.
And if the spouse passes through,
If the spouse passes too, then the kids, if the kids are still alive, then the kids would still get it per state laws, whatever the state law would be, which usually would end up being equal between the kids. Now, if you also pass away with no plan and you don't have any, and your kids are minors, then obviously then one of two things can happen. One, somebody, family, friend, somebody steps up and goes to the court and says, I'm going to raise these kids now. But if that doesn't happen, then they'll go into foster care.
another follow-up question. According to Sharia law, like the الذكر مثل حظ الأنثيين, can you establish that in a trust, for example?
Yes. So the question was, can you establish the Sharia in your trust? Yes, that's where you have the control. So if you have a will or a trust, the court's main objective always is to enforce your wishes, right? So enforcing your wishes, it's your assets, your money, you can give it to whomever you want, however you want. So they won't interfere in that aspect of it. But yeah, in the trust, because it's more private, it's, you don't get courts involved, it's simpler because you don't have to go through the whole court to show them and convince them the Sharia parts of things. But to answer your question directly, yes, in any estate, whether it's a will or a trust, you can establish the Sharia as part of that if you're beneficiaries. Sorry, I know there was a question right there, yeah.
Yes, are the assets still transferred as a will in your personal name if, like, your home is in an LLC?
So are the assets still in your personal name if it's in an LLC?
No, are the assets transferred, distributed properly as it would be if it's in your name?
So when you haven't, so
If it was an LLC, but your house is an LLC, how would that distribution to the beneficiaries be? Would it be the same?
the equity of the LLC gets distributed.
Okay.
So the question is, if you have a property in an LLC, how does that get distributed upon your death? So the answer is that the LLC equity, so if you own 50% of that LLC, that 50% of the LLC is what gets allocated in your estate, not the house or the property itself. So I just want to come, yeah.
Just